Good afternoon. Thanks for inviting me down this afternoon. My subject is succession with tenanted land, and it can be quite a dry subject depending on the audience. But because the audience today is not technically legally targeted, I'm going to try and keep it fairly sort of general to give you a sort of a feel as to what points need to be taken into consideration when looking at the next generation taking over a farm. Tenanted land can be a very general definition, if you like, but it can take many forms, and I think a better way to describe it would be farming land that you don't own. So it doesn't have to be a landlord-tenant relationship, it can be a number of different types of relationships, and I'm going to touch on the main ones this afternoon, some of which could affect the farms or the farm that is part of this project. So we have different types of tenancies or different types of ways of occupying land that you don't own. Lifetime tenancies, that's the first one we'll touch on. These usually start before 1995 because legislation changed in 1995. So if a tenancy started before 1995, then it will usually be a lifetime tenancy. Any tenancies that started after 1995 will usually be farm business tenancies, and we'll touch on those. Short-term lets, grass keeps and away wintering. These are sort of arrangements, sometimes done on a handshake, sometimes done on a piece of paper, which are probably very common and probably more common than a lot of people realise. So a lot of farmers who may say, I'm not a tenant farmer, they may well not be a tenant farmer in the general sense, but they may rent a bit of land or have a couple of acres down the road that they take, or grow a bit of silage in the next parish that they do on a yearly basis, and they'll fall into that category. And then you have what I've called other quasi-arrangements, other arrangements for occupying land that you don't own, and these can include things like share farming, contract farming, etc. And I'll touch on those slightly this afternoon as well. So dealing with lifetime tenancies, first of all, these are the only types of agricultural letting, the only types of agricultural tenancies that have automatic rights to succession. So if you have a farmer who is in his 70s, for example, and been farming a block of land since, say, 1965 or something like that, under a tenancy, then he will have the automatic right to try and get his son, daughter, or possibly brother, sister, or spouse onto the tenancy as and when he either wants to retire or if he passes away. To be a lifetime tenancy, you would have to have started before 1995. To have succession, automatic succession, there's another date for you. It had to have started before 1984 because succession itself was abolished in 84. County council tenants don't get succession, just as a matter of interest, and also you don't get any more than 2 generations allowed to succeed. So grandfather, father and son can stay on the tenanted farm, but beyond that there is no succession rights. Well, I've just said it's automatic. It's not necessarily automatic. You have the right to apply, you have the right to pass the tenancy on to the next generation, that's automatic, but you don't necessarily have the automatic right to have the tenancy. If the landowner, who might want the land back himself to sell it or to farm it himself, if he doesn't agree with the next generation taking over, then the person who wants to take the tenancy must prove themselves to what is known as the Agricultural Land Tribunal. That's like an agricultural court. And they're the ones that make the decision on whether or not the next generation can take over. The person applying for the tenancy can either do so when the tenant reaches the age of 65 or after the tenant has died. The person applying must be a close relative, and that is quite tightly defined. It's got to be a spouse, sibling or child. And the applicant must show that they rely, and this is the big test, they've got to show that they rely on their farm for their livelihood. The whole point of succession is to allow farms to move down the generations, but only when the generations rely on that farm as their main source of livelihood. They don't want, the law wasn't brought in to accommodate hobby farmers, for want of a better phrase. It's got to be people that rely on farming, and farming is their livelihood and their mainstay. And the applicant must also show that they've got reasonable experience, that they're healthy enough to carry on the farm, and that they have the finances. And this can normally be proven with a doctor's letter and a letter from the bank, etc., etc. And if they've been farming with the father or with the tenant for 20, 30 years, then the experience is almost a foregone conclusion. There are a number of hurdles the person applying has to reach or has to meet. Ironically, for various reasons, succession on the death of the tenant is actually easier to achieve than succession on retirement. But, and this is one of the important things that a tenant must realise, or an applicant must realise, that they must apply for the tenancy within 3 months of the date of death. I just had a client phone me up on Saturday to say that his father had sadly died Friday night. I've got to go and see him tomorrow because we've got to get that application in. 3 months will soon fly by, so it's very important to get that application in. If you don't get the application in, then it's the end of the story. The benefit of going for succession, planning ahead and going for succession on retirement, is that if things are starting to look a little bit awkward or things aren't working out, and the landlord or the landowner is really objecting, and certain things have cropped up that they didn't expect, then you can actually withdraw the application, sort out whatever was wrong, and try again. Obviously, succession on death, you only get one chance, so that's why the succession on death criteria are a little bit more relaxed, because you do get more chances on retirement. But the message really, for the purpose of this afternoon, and also for the project, I think, is and looking at the hypothetical farmer that we're looking at that you're looking at in the project, is that with careful planning, the next generation can usually succeed to a tenancy on retirement. And by careful planning, I, as an advisor, normally say to clients, if you give me 5 years, we need to plan ahead 5 years. But if you plan ahead for 5 years, then I can almost guarantee that you can get your tenancy, or your father, or the tenancy into your generation. So in a situation where you've got a tenant who's been taken very ill, and I had a very similar case to this down in Glamorgan last year, where sadly the tenant had been given 6 months to live. If you're given a bit of a head start, a bit of an opportunity to plan ahead, then you can, with careful planning, get the tenancy to that next generation. So in the situation with this case, where the father has been taken gravely ill, then again there is a possibility that if there is tenanted land within that farming business, there's a good chance that it can be passed on to the next generation. That, of course, is if the tenancy has succession rights, and we'll come on to a whole range of tenancies that don't have succession rights, including lifetime tenancies that started after 1984. So what do you do in those circumstances? Well, the key really is negotiate. You need to sit down with the landowner and ask him what his aspirations are, what he would like to do, and whether or not he's happy for the next generation to take over. With lifetime tenancies, the landowner himself is also under certain deadlines. He's got 3 months after he's told about the tenant's death to get his notice to say he wants the tenancy to come to an end. So there's a little bit of a flurry of activity at the beginning, whereas you'll remember that the applicant, the person applying, has got to get his application in within 3 months of the date of death. The landowner gets a little bit longer because he won't have been notified straight away, but as soon as he's notified, he's got 3 months to get his notice to bring the tenancy to an end in. So after the formalities are out the way, then it's a matter of the parties, I always recommend, sitting down around a table and negotiating the best way forward. The important thing to note, though, is that because if the tenant has died, the tenancy will come to an end. It may pass on to the next generation and become a new tenancy, but the old tenancy will die with the tenant, and that will happen at what they call the next anniversary date. So very often tenancies are what they call Lady Day tenancies, which is 25th of March, or Michaelmas, which is 29th of September. So if, for example, the tenant died today and they were a Michaelmas tenant, a 29th of September tenant, then the tenancy would come to an end 12 months from the next anniversary date. So it would be, in this instance, would be September 2014. So you still have quite a long time to get your act together. The tenancy doesn't come to an end the same day that the tenant dies. It can be anything up to, in theory, 2 years from the day that the tenant dies that the tenancy itself actually comes to an end. So we then move on to other ways of occupying land. Well, farm business tenancies, they're becoming more and more prevalent now because they were introduced in 1995. You don't get lifetime tenancies anymore, other than the ones that already exist. So if somebody takes a new tenancy now, it will be a farm business tenancy. They will be always for a fixed period of years. You can't have a farm business tenancy that goes on until someone passes away. It'll be 10 years, 20 years, 30 years, 6 months, however long they agree. It will be a fixed period. No succession rights, that's it. There is no succession with a farm business tenancy. If the landowner wants the land back at the end of the tenancy, then that's it. The tenancy will come to an end. The right to assign. Now, assign is the way a tenancy can be passed on, or by what they call assignment. Very, very rare in farm tenancies. Shop tenants, factories, industry, that sort of thing will often have the right to assign. So if you take out a 25-year lease for a shop in the middle of the high street in Carmarthen, and 5 years down the road you don't want to do that business anymore, then you can pass that lease on to someone else. That's called assignment. You don't get that in farm tenancies, or very, very rare anyway. So whether the tenancy will continue after the death of the tenant depends on the tenancy itself. If it's a 20-year tenancy and the tenant dies after year 10, then unless the agreement says otherwise, that tenancy will continue to the end of the 20 years, and the beneficiaries or the people, the executors, will have to carry on farming or have to manage that farm for the remaining 10 years of that 20-year tenancy. Having said that, most farm business tenancies have a clause in the agreement to say that if the tenant dies, the tenancy comes to an end. So it's unusual to see a tenancy that carries on beyond the death of the tenant. Again, it comes down to negotiation, which is what we do a lot as a business. The landowner may just be an investor who doesn't want to farm himself, and because he's quite happy with the family and known them for many years, may be quite happy for the next generation to take over. So it's a matter of sitting down with the landowner and seeing what he wants and what his aspirations are. And the arrangement between the parties can be structured to allow the next generation to continue if that's what suits everybody involved. So with farm business tenancies, invariably you'll have to approach the landowner. We'll probably have to renegotiate the rent and other terms. So the landlord might want to put the rent up, or he might want to have some new terms to do with repairs or something like that. But it's always be prepared to expect to have to renegotiate. But do bear in mind that a good tenant is worth, in my view, at least £20 an acre. Someone who pays his rent on time, someone who does his repairs, someone who doesn't wind the landlord up and doesn't cause problems, is worth at least £20 an acre. So a farm business with a tenant who's passed away approaching a landowner should go forearmed with that information, thinking, well, if the landlord is keen, should be fairly keen to keep me, therefore I've got a little bit of a negotiating position here when I go and see him. So coming on to other ways of occupying land that perhaps are more or generally less known, and people perhaps don't appreciate our actual tenancies. I've sort of headed a general, sort of very vague sort of short-term lets, grass keeps, etc. Many farms, I would say probably 60, maybe 70% of all farms have some other land on some sort of short-term let. They might just be taking land for 6 months because they want to put the sheep there for the summer, or they might want to grow a bit of silage, or might want to grow a bit of corn. But I would say a significant majority of farms will have some sort of short-term arrangements other than the land that they own. Again, absolutely no rights to succeed. You might, or the farming business might have had that occupation year in, year out for 6 months every summer for the last 25, 30 years, but that doesn't give any long-term rights to carry on beyond the death or the retirement of the tenant. So again, you need to approach the landowner to discuss as soon as possible, and the same things apply with farm business tenancies really. If you've kept a good relationship with the landowner over the years and you've paid the rent on time, then there's no reason why the landowner wouldn't let the farming business carry on with the son or daughter taking over from the retiring or tenant who's passed away. Again, in those negotiations, we would always emphasise the benefits of dealing with a tenant that the owner already knows. Better the devil you know, as they say. And that would be very firm advice to go in to such negotiations with. And again, you may need to offer better terms, slightly better rent, or renegotiate how long the land is rented for, or maybe agree to cut the hedges or something like that, but just to sort of give a bit of an enticement to the landowner to let the land carry on. It's always important to realise that you might have a home farm of 100 acres, and sometimes up to another 100 acres could be on short-term lets. So half the business could be reliant on short-term lets. Very often also, of course, the main farm itself will be a lifetime tenancy, completely different scenario. But when a large part of the business can depend on short-term lets, then it's quite an important thing to realise that you do need to talk to the owner of the land if the business is to continue in the way that it has in the past. Other arrangements Now these, they can come under all sorts of names. They can be called share farming agreements, they can be called contract farming agreements. Really what they're usually set up to avoid something. Up until the law changed in 1995, if you let someone have your land and rented it to them, then there was a risk that you could lose that for the lifetime. You could end up losing that for 20, 30, 40 years. And that's what was called security of tenure. So these sort of odd arrangements, I call them odd, but they were set up really to avoid, up till 1995, security of tenure. So really what they were was just tenancies by another name. Now, because security of tenure doesn't really exist on farms, they're now set up to avoid things like inheritance tax or capital gains tax, income tax, or not avoid, but mitigate, I think is probably the right phrase I should be using for HMRC are listening in, set up to mitigate tax. So you'll come across these sort of arrangements that look like partnership agreements, share farming, contract farming, but actually they're just, in many instances, just set up to avoid something. I'd say they're usually just a tenancy by any other name, whereby the farmer himself farms the land and the landowner sits back and doesn't actually do much other than collect a payment for having the land occupied by somebody else. Again, no succession rights, basically because there is no law governing contract farming, etc. So there's no rights to continue. But again, need to negotiate with the landowner, who will probably be keen to continue, as he'll want to retain the status quo. If he's set, the whole basis of the thing has been set up to avoid or to mitigate tax, then he's not going to want to rock that particular boat. So it will be well worth going and sitting down and talking to him to see how you can continue so that he retains whatever he wants to retain, whereas at the same time the farm business can carry on and pass on to the next generation. Just before I summarise, there's one thing I haven't put in there is unwritten agreements. I was thinking about that on the way down, actually, as I was driving down this morning. Not quite as common as they used to be, but you do very often come across arrangements where there's nothing in writing between the parties. Farming as an industry is very much word of mouth, very much done as on a handshake, gentleman's word, that sort of thing, gentleman's agreement. Again, the basic rules are that if the arrangement, the unwritten arrangement, started before 1995, then even though there's nothing in writing, it may well be a lifetime tenancy. If it started after 1995, then it'll be either a short-term tenancy or a farm business tenancy. In those circumstances, it's very, very important to take advice to make sure you know what you're dealing with. And again, these blocks of land can soon add up. They could be anything up to 50 or 60% of the farm business. It can be a very important part of the farm business. And without those extra bits of land, then the farm business would look very, very different. So it's very important to know where you stand in those circumstances. So coming back to the summary, well, it's always important to plan ahead. As I mentioned before, I always say to my clients, give me 5 years. And tell me if the farmer, the tenant comes to me when he's 60 and wants to retire when he's 65, give me 5 years and I can get your son or daughter onto that tenancy, almost guaranteed, as long as they are prepared to make the sacrifices that go with it. A very good example, we did a negotiation for a client up in Cheshire. It was the daughter who was looking to take the tenancy over. Father was 62 and she wanted to take over the tenancy, and all was looking fine until we found out that her husband was a very successful cattle dealer and was making about £100,000 a year dealing cattle. Now, of course, going back to the earlier point, in those circumstances she wasn't relying on the farm for her main income. Her main income was being relied upon for the cattle dealing. But it was a very nice Cheshire farmhouse, a couple of 100 acres. Lifetime tenancies are absolutely worth their weight in gold. She wanted to know what could she do. So we set up a farming business between her and her father. Her husband stopped taking drawings from his business for 5 years. So instead of living the life of Riley on £100,000 a year, they had to live for 5 years on her earnings from the farm business, about £20,000 a year, which is still a good income. But I mean, compared to living off £100,000 a year, they had to cut back on a lot of things. And they did that for 5 years, but that was a huge sacrifice. They had to cut back on an awful lot of things to live quite frugally for 5 years on £20,000 compared to what they had. But at the end of the 5 years, we got her the tenancy. And then, of course, her husband could then go off and start drawing his money off the business after that, because once she was in there as tenant, there was nothing more the landlord could do. In fact, what happened was after 4 years, the landlord realised what we were doing, realised he couldn't do anything about it, and gave her the tenancy. But the point being, I come back to, is that with careful planning, you can achieve this. It's very important to get started sooner rather than later. With the exception of lifetime tenancies that started before 1984, you will need to negotiate with the owner. That's the message. You need to sit down with the owner and say, well, look, my father's ill, my father's retiring, my father's died, whatever it is, whatever circumstances are, I would like to take over the tenancy. I want to carry on farming. What can we do? What can we talk about it? You need to sit down with the landowner. As Churchill said, jaw, jaw, not war, war. That's got to be the way forward. Watch deadlines for applying. If you do have a lifetime tenancy, I say they're worth their weight in gold. They are becoming, no, not quite hen's teeth yet, but they're becoming rarer and rarer because they stopped in 1995. And if you have a lifetime tenancy, you need to protect it at all costs. You've got that 3-month deadline, especially very often is like the chap whose father died on Friday. The farm is his home. He lives there. It's not just a few acres down the road. It's his house, his buildings, his business. Everything depends on him getting that tenancy. So it's absolutely crucial. If you miss the 3-month deadline, you're out of the game completely. If a tenancy does come to an end, know your rights, because you might have spent a lot of money on the land, you might have put fences up, you might have put a lot of fertiliser on, you might have even put the odd shed or building up. You are entitled to compensation under certain circumstances, but again there are deadlines to watch, so be careful, make sure that if the landlord says no, you can't have the tenancy, make sure that you get advice on getting properly compensated. And as I always say at all my meetings and all the presentations I do, very few people actually read their tenancy agreement. First starting point, read the tenancy agreement. They might appear double Dutch, but actually when you sit down and read them, they can be fairly enlightening. You don't necessarily need to employ expensive land agents and solicitors to come and tell you what is actually in front of you. Very often sit down at the kitchen table with a strong glass of wine, a good glass of wine, and try and read through it yourself. And if you're not sure, then take advice, but read the tenancy agreement. And as I say, the bottom point, take advice if you're unsure. And that really is a whistle-stop tour through what I've done for the last 25 years, compressed into about 25 minutes. So I hope that's of interest.
Diolch yn fawr iawn.
Croeso.